Hello, I'm Jane Tenquist, partner and head of the family team at Myerson. Currently, we have 4 solicitors in the team and a trainee solicitor. How can I protect my wealth before marriage? The most effective way to protect your wealth prior to marriage is by entering into a prenuptial agreement with your fiancé before the wedding. Prenuptial agreements are becoming increasingly common. Although prenuptial agreements are not strictly legally enforceable, which means there's no absolute guarantee that the terms of the agreement will not be challenged in the divorce court, the courts in England and Wales are increasingly adhering to the terms of prenuptial agreements if certain criteria are met. Both parties must receive independent legal advice prior to signing the agreement. Both parties must provide financial disclosure so that each party is aware of the extent of assets owned by the other prior to marriage. The terms of the agreement should be fair and reasonable. There must be sufficient time between signing the agreement and the wedding to avoid any suggestion that the parties have had inadequate time to consider the terms of the prenuptial agreement properly. The agreement must be signed at least 4 to 6 weeks before the wedding. Neither party must have been coerced by the other or placed under unfair pressure or duress to sign the prenuptial agreement. How can I protect my wealth after marriage? The most effective way of protecting your wealth after marriage is to enter into a post-nuptial agreement. Again, the parties to the marriage must be separately legally represented. There must be full financial disclosure. The terms of the agreement must be fair and reasonable. But there are other ways to protect non-marital wealth, such as a declaration of trust. If you buy a property in joint names with unequal financial contributions towards the purchase price and mortgage repayments, it is sensible to clarify ownership of the property by entering into a declaration of trust which specifies how the net proceeds of sale are to be divided on sale or transfer of the property. Alternatively, you may be able to protect funds advanced to you by your parents by way of a loan, which clarifies how the loan is to be repaid. In a subsequent divorce, it may be far easier to persuade a judge that a contribution from one party's parents towards the deposit on a family home was a hard loan which needs to be repaid rather than a gift. Alternatively, setting up a trust to preserve family wealth for future generations is a very effective mechanism to protect family wealth on divorce. A trust can be set up for a variety of reasons, including to control and protect family assets when a person is too young to handle their affairs or to pass on assets while the settlor is still alive. A discretionary trust is a really effective mechanism to protect family wealth. Funds can be advanced to beneficiaries of the trust at the discretion of the trustees. The beneficiaries may receive regular income or capital from the trust, or sometimes the beneficiaries may receive nothing at all. Can the family court attack a trust on divorce? Yes, there are various ways in which the family court can attack a trust on divorce. Firstly, the court could find that the trust constitutes a nuptial settlement, which means that there is a connection between the settlement and the marriage, or that it makes some form of continuing provision for one or either of the parties to the marriage, with or without provision for their children. If this is found to be the case, the court can make an order to vary the trust. The second way that the court may attack a trust is it can challenge the validity of the trust either by finding an issue with its technical creation or deciding that it's a sham trust. One of the most common reasons for determining that the trust is a sham is that the settlor retains a level of control which undermines the powers and duties of the trustees. If this is found to be the case, then the protection that the trust offers is at risk of being lost, and the assets may be found to be personal assets of the settlor. It is therefore important that expert advice needs to be obtained at the outset, and that letters of wishes are carefully drafted so that appropriate regard is taken to ensure that the trust is protected as far as possible from any challenge by the court. Finally, The court can view the trust as a financial resource of one party and make financial orders accordingly. For example, a trust resource may have been used to purchase a family home, or income from the trust might have been advanced regularly to fund standard of living expenses. It is therefore important that appropriate care is taken when drafting a trust deed to protect trust assets from being considered as a potential financial resource. How can we help? All the solicitors in the family team are members of Resolution, which is a national body of family lawyers who are committed to resolving financial disputes in as non-confrontational a way as possible. All our solicitors have accreditations and extra training in complex financial remedies, injunctions and private children work. We actively encourage mediation and other out-of-court options to resolve difficulties on relationship breakdown. However, we do not shy away from issuing court proceedings when this is necessary to protect the client's interests. Myerson is not a niche family practice, it's an all-service law firm. We work closely with other specialist solicitors in other departments to ensure that clients receive the most commercially sound advice when considering how divorce affects their business, their property rights, their private wealth and trust issues, and their income. We appreciate that the breakdown of a marriage is a very upsetting time, and it is often difficult for emotional and financial reasons. At Myerson, we have excellent links with personal counsellors to assist clients during this process. If clients are experiencing financial difficulties paying their legal fees, we may also be able to help them with applying for a litigation loan, which is typically repayable at the end of the litigation.